Hello. Am I audible to you?
Yes, sir. Yes, sir.
Yes, sir, you're audible.
Okay. Yeah.
Good evening, all of you. Thank you for joining today to the fourth day of our online lecture series. Today's guest speaker is Dr. C.H. Divakar Babu. We welcome you, sir. Thank you for joining for the lecture
Thank you.
series. Now I invite Ms. Gopika to give the introduction of our guest speaker.
Thank you, ma'am. Good evening to one and all. Today we are gathered here as part of fourth day Human Right Law lecture series being conducted by Department of Law, Central University of Karnataka. It is my privilege to introduce Dr. C.S. Divakar Babu sir to this program. Dr. Chennupati Divakar Babu was born on 24/12/1960 to late Sri Chennupati Nageshwar Rao and late Srimati Chennupati Mangamma. He had primary education at Patibandala Sitaramaya High School at Gundur and later obtained graduate degree in commerce from the JKC College Gundur and master's degree in sociology and law from Nagarjuna University and secured doctoral degree for his thesis on the Competition Act 2002 from Sri Venkateswara University, Tirupati. He started his academic career as assistant professor in law in Srimad V.D. Siddhartha Law College, Vijayawada, and presently working as principal professor for the past more than 8 years. He published more than 40 articles in renowned legal journals on contemporary legal topics. He contributed articles to regional newspapers on diverse topics of socio-economic and legal importance. He was an expert member for the drafting of consumer law for the Royal Bhutanese government, and he is the founder secretary of Consumers Guidance Society and president of Corporate Frauds, which filed more than 3,000 consumer cases by exposing the cause of aggrieved consumers and filed criminal and consumer cases against multi-level marketing companies like Amway, Gold, Quest, Peak, Asia, etc. He filed medical negligence cases on behalf of victims of medical malpractices against many hospitals in Vijayawada and Gundur with a success rate of 100%. I once again invite Dr. C.S. Divakar Babu sir to share his precious views on today's topic, transformative constitutionalism and human rights. Thank you. Thank you all.
Okay. Thank you so much. Are you able to hear me?
Yes, sir, you're audible.
Thank you so much for giving me a wonderful opportunity to share some of my ideas, thoughts on transformative constitutionalism and human rights. You all know pretty well that Constitution, our Constitution was drafted more than 70 years back. So when our Constitution was drafted, there was nothing like information technology, artificial intelligence, machine learning. And some people question the utility of Constitution and its philosophy to the changing times and needs. So some people ask, is the Constitution still relevant to the Indian conditions, needs, necessities? So the answer is a loud and bold yes. So what do we mean by transformative constitutionalism? Transformative constitutionalism is nothing but making the Constitution relevant to changing needs, times, and necessities. Okay? So therefore, constitutional transformatism is nothing but to make constitution sensible to the needs and necessities of the contemporary times and also to the times of future. And here I would like to share an important outcome of the research done by Chicago University. Chicago University in the United States of America had done a research project about the longevity, vitality, and utility of the constitutions across the world. And they came out with shocking results. The results disclosed that most of the constitutions had validity of 10 years, 15 years, 25 years. And there were very, very few constitutions which have so much longevity, relevancy, vibrancy, vitality. And one of the constitution is indisputably the Indian Constitution. So that shows the resilience of the Indian Constitution. So before going into the nitty-gritty of the topic, the first and the foremost question that creeps into our mind is, what is Constitution? A Constitution is a roadmap for good governance. It contains what the organs of the state can do and cannot do, or it contains do's and don'ts for the organs of the state like legislature, executive, and judiciary. It also contains how a citizen, how the citizen can blossom his or her personality. So our constitution is unique in the sense it not only prescribes the domain within which each organ of the state has to function, and at the same time it prescribes what the state has to ensure to facilitate the flowering and blossoming of human personality. So therefore, it is the fundamental document proclaiming its supremacy, rule of law, and vesting of the sovereignty with the people. So our constitution is always governed by its supremacy, and at the same time, it also recognizes that sovereignty lies with the people. So coming to the transformative constitutionalism in relevance to human rights. So at the beginning, the Constitution was understood as a document of some rigidity, and it cannot be made flexible, relevant to the changing needs and conditions. And during those days, even the Supreme Court was very, very conservative in the interpretation of the constitutional provisions. So as the things moved on, the mindset of the framers of the Constitution and the philosophy behind the Constitution and the aspirations and intendments of the constitutional makers was given effect to, and with that there is an outcome of transformative constitutionalism. And if you see the earlier trend, so during the earlier trend, starting with A.K. Gopalan case, where the Supreme Court held due process of law was not a part of the Constitution, and subsequently when we trace, when we analyze the cases decided by the Supreme Court from 1973 onwards, starting from case 1 on the Bharati case, where the Supreme Court said that there are certain essential values, or there are certain core values which are non-negotiable and which are the part of basic structure of the Constitution, and the amending power of the Parliament doesn't extend to abridge, cut away, or denote, or take away those essential features which are a part and parcel of the basic structure of the Constitution. That means the basic structure of the Constitution is beyond the amending power of the Parliament under Article 368, and therefore the amending power of the Parliament is limited. So Though Parliament is a sovereign body, but it has a limited sovereign power as far as amending the basic features of the Indian Constitution are concerned, because the basic features of the Indian Constitution, which include a catene of things like rule of law, democracy, secularism, uh, equality before law, so on and so forth, are inviolable, and they are beyond the amending power of the Parliament. And coming to the relevance of transformative constitutionalism and human rights, you are quite aware that our Constitution recognizes certain rights as fundamental rights or basic rights or natural rights, which are inviolable, sacrosanct, sacred, though they are not absolute, because the state can impose some reasonable restrictions on these fundamental rights on the ground of public morality, unity and integrity, public health. But at the same time, here, naturally a question arises. Are all human rights are fundamental rights? Or what is the exact relationship between fundamental rights and human rights? It is true, fundamental rights and human rights converge. But at the same time, human rights have the widest possible meaning, because human right includes every right which is essential, indispensable, and sine qua non for the flowering, blossoming of human personality. Okay, so right to development is a human right, but it is not included explicitly in our Constitution. So right to basic needs is a human right. Right to sound and salubrious environment is a human right. So these rights, which we recognize as human rights, were not explicitly included in our Constitution, but during the course of dynamic proactive interpretation of the provisions of the Constitution, these rights have come to be have been included within the umbrella of the fundamental rights. That I will be dealing with more specifically. And starting with case one of the Bharati case, subsequently we have so many cases wherein the Supreme Court has emphasized very emphatically that fundamental rights invariably include human rights. Okay, so to take a to let us see some important case laws for understanding this. In case Puttaswamy versus Union of India, you all know pretty well Article 12 of the International Covenant on Human Rights, or Article 12 of Declaration of Human Rights, International Declaration of Human Rights, explicitly recognizes privacy as an important human right. You all know, you are quite familiar with that. So Article 12 of International Declaration on Human Rights explicitly recognizes right to privacy is a basic and fundamental human right. At the beginning, starting from MP Sharma versus Sati Chandra in Karak Singh case, our Supreme Court held, though privacy is important, but it is not included within the ambit of fundamental rights. But in the year 2017, a 9-member bench of the Supreme Court has categorically observed, in the era of technology, there are chances for invasion of privacy. So when privacy is affected, individual dignity is also affected, because there is a close nexus between right to privacy and right to dignity. So therefore, the Supreme Court held in unequivocal terms, right to privacy is essential not only for protecting the individual autonomy, but also the dignity of an individual. Right to privacy is also important for upholding the honor, dignity, and reputation of an individual. Therefore, the court held right to privacy is implicit or implied in Article 21 of the Indian Constitution. So that means A right which was recognized, a right which has been recognized in Article 12 of the International Declaration on Human Rights has been read into Article 21 of the Indian Constitution. You see the relevance, you see the relationship, nexus between fundamental rights and human rights. That is what we exactly mean. What is meant by transformative constitutionalism? That means, so transformative constitutionalism is nothing but making the constitution relevant to the changing times, needs, and and in the era of what you say as changing. So we're seeing so many changing phenomena like emergence of new technologies, globalization, privatization, liberalization. Even then, the constitution which was enacted 70 years back is still made relevant, meeting the needs, intentions, and aspirations of the people. That is what we mean by the uh, that is what we mean by constitutional transformation. Similarly, in our constitution is founded on the bedrock of egalitarian citizenship. Egalitarian citizenship means all the citizens, irrespective of caste, creed, race, language, religion, descent, or place of birth, are equal. So citizens cannot be discriminated on the ground of certain irrational grounds like sex, religion, race, language. That is what is meant by equal citizenship. So this equal citizenship is also one of the important principles recognized in the International Declaration on Human Rights, 1948, even in the International Covenant on Civil, Political, and Economic Rights. Okay, so our Supreme Court in Joseph Shine versus Union of India has rightly held Section 497 of the Indian Penal Code dealing with adultery is not valid. In this case, the Supreme Court held that women and men are equal and there should be no discrimination. So, any legislation which doesn't recognize the autonomy of women and which discriminates women on the basis of sex and treats men and women unequally is a constitutional anathema and therefore it is not valid. So in this case, the Supreme Court further held that discriminating women on the ground of sex and treating men as superior to women is not constitutionally permissible. Therefore, Section 497 of the Indian Penal Code was struck down. Similarly, in Navjot Singh Johar versus Union of India, the Supreme Court, in this case, the question that arose before the Supreme Court was whether consensual sex in between the members of the two individuals is violative of Section 377 of the Indian Penal Code. In this case, the Supreme Court held no person shall be discriminated on the ground of his or her sexual orientation. Our Constitution is built on the edifice of egalitarian citizenship. So when persons are discriminated on the basis of their sexual orientation, it violates the constitutional morality and therefore it is not valid. In this case, the court further held that discriminating an individual on the basis of his or sexual orientation hits at the very concept of egalitarian citizenship and therefore it is not valid. So that means the Supreme Court has recognized the concept of the egalitarian citizenship irrespective of caste, creed, language, religion, race, sex, descent. So this is also one of the fundamental premise of the International Covenant on Civil, Political, and Economic Rights and the International Declaration on Human Rights. You see the relevance between the two. So that's it. That is what do we mean? That is what we mean by constitutional transformatism, making the constitution to the changing needs of the society. And here, and similarly in uh, Indian Youth Bar Association versus the state of Kerala, popularly known as the Sabarimala case, where the question that arose before the Supreme Court was whether the custom or ritual practiced among the Hindus by which menstruating women from 12 to 45 or 50 were barred from entering into sanctum sanctorum of Ayyappa Swami's temple was constitutionally tenable. In this case, the Supreme Court held when there is a conflict between majoritarian morality or religious morality and constitutional morality, then constitutional morality shall always have preeminence. And in such an eventuality, constitutional morality always prevails over religious morality or majoritarian majority. So the court in this case had extensively and elaboratively discussed that majoritarian morality or religious morality or social morality may be popular. It may be acceptable to the majority of the community. Nevertheless, when majoritarian morality is against the constitutional ethos, then constitutional morality alone shall have preeminence. So in all these cases, starting from Joseph Shine, Navjot Singh Johar, and Indian Youth Bar Association versus the State of Kerala, in all these cases, the court had consistently and continuously emphasized a very important principle. The principle was our constitution aims to promote and uphold the plurality of life and inclusive society. So when majoritarian morality goes against the plurality of life and inclusive society, then the then then the constitutional morality alone shall prevail. So similarly, in Shakti Vahini versus Union of India, where the question that arose before the Supreme Court was whether family or clan or relatives could interfere in the woman's freedom of choice of selecting her life partner, the Supreme Court held that woman had absolute right to choose her life partner. Neither her parents, nor her relatives, nor the clan could interfere in the woman's choice of selecting a life partner. Okay, so that is what the Supreme Court held. Similarly, in R.L. Coelho versus the state of Tamil Nadu, the Supreme Court held that after April 24th, 1973, if any law was placed in the ninth schedule stating that it was beyond the scope and ambit of judicial review, nevertheless, it is not valid. So that means there was a practice uh, by which there was a constitutional practice before R.L. Coelho case. The constitutional practice was making more and more number of laws under the ninth schedule, stating those laws put under ninth schedule were beyond judicial review. And though those laws were against the spirit of the fundamental rights or the basic tenets or basic features of the Constitution, yet they cannot be challenged and they are beyond judicial review. But however, the Supreme Court in R.L. Coelho case had stated that every law that was included in the ninth schedule after April 24th, 1973 would be subject to judicial review. And if that law goes against the very spirit or goes against the core values of the Constitution, nevertheless, it can be challenged. Similarly, in Arun Shabak case, and we have many a time we are in a dilemma whether the right to life includes the right to die. So there were certain controversial decisions given by the court, but in Arun Shabak case, the Supreme Court has held right to die in dignity is also a part of right to life. Therefore, silent euthanasia is always permissible. So therefore, a person can, where a person is in a state of complete vegetation, and if that person had a desire that his life should be terminated, and do where when he was in a state of activeness, he had executed a will saying that in case if I happen to meet with any accident leading to a state of vegetation, in such a case my life may be terminated, then it may be given effect to. So they, where the court has clearly held that right to life also includes right to die. So we have seen, so similarly, we have seen so many cases like this where the court has extended the ambit and remit of Article 21 of the Indian Constitution. What does Article 21 says? Its essence is very simple. It simply says, no person shall be deprived of his life and personal liberty except in accordance with the procedure established under the law. No person. So the word used is no person. So it is the word. So the architects of our Constitution had deliberately used the word person, not citizen. That means this right, this fundamental right to life and personal liberty is applicable, can be invoked by every citizen as well as non-citizen. So no person shall be deprived of his life and personal liberty except in accordance with the procedure established under law. But however, at the beginning, the Supreme Court was so conservative and not progressive in its approach. So at the beginning, the Supreme Court in the A.K. Gopal case had held that a person could be deprived of his liberty or life in accordance with the law or procedure made by the executive, though that procedure was unjust, unfair, and unreasonable. That is what the court held. But this decision made in A.K. Gopal case saying that a person could be deprived of his life and personal liberty by a law made by the executive, though that law prescribes a procedure which is patently unjust, unfair, and unreasonable. And even then, the court could not interfere because due process of law was not a part of the Constitution. That was what the court held in A.K. Gopal case. But this decision was reversed or quashed in Maneka Gandhi versus Union of India, where the court had said that the decision given in A.K. Gopal case was patently erroneous and against the very spirit of the Constitution, saying that due process of law was definitely a part of our Constitution. The court said a person could be deprived of his life or personal liberty provided two conditions are satisfied. That is, there must be a law, and the law prescribes a procedure, and the procedure must be just, fair, and reasonable. So the court for the first time had read due process of law into Article 21 of the Indian Constitution. And from that time onwards, the court has expanded the very ambit, scope, and remit of Article 21 by including a catene of human rights within its umbrella. For example, the court said the right to pension is a fundamental right within the ambit of Article 21 in Nakara case. Okay, right to access to road is a fundamental right. Similarly, in Pachim Bangla case, the court held that right to health is a fundamental right. So, similarly, right to food in PUCL versus Union of India, the Supreme Court held right to food is a fundamental right. Okay. Similarly, in Nalsa versus Union of India, the court held that even transgenders are citizens of this country, so there should be no discrimination against transgenders. So therefore, they are also eligible for the state entitlements of reservation. So the court made a catene of rules for ensuring that transgenders are treated equally. Okay. So similarly, the court held in Vishaka versus state of Rajasthan. The court held in Vishaka versus state of Rajasthan that the discrimination at workplace is against Article 14, 15, and 21 of the Indian Constitution. Therefore, women should not be discriminated at the workplace. The court made a catene of rules which were later enacted in the form of law. Similarly, so from this, what we can understand is, at the beginning, the court adopted conservative and retrograde approach in interpreting Article 21. Later, the court had adopted a dynamic, vibrant approach in interpreting Article 21, and thereby the very scope and extent of Article 21 has been extended very elaboratively so as to include almost all the human rights, which include right to food, right to health, right to pension, right to access to roads, right to live in a conducive environment, right to shelter in Volga Telly's case. Okay, so from this, what we can understand is, so a constitution is not something like an ordinary law. A constitution is an organic document. It contains the very vision, mission, dreams, aspirations, inspirations of the architects of our constitution. That is what we collectively called as the constitutional philosophy. So therefore, it is not an ordinary law. So it is an organic document. It is having a life in it. Okay. So that is where the importance, significance of the constitution comes into being. So therefore, the constitutional courts have grasped this organic nature of the constitution, and where the courts have started to interpret the provisions of the constitution not in the literal sense, but by taking the dreams, aspirations, the debates, discussions that took place in the constitution, in the constituent assembly, and this has invariably resulted in the constitutional transformatism. Okay, so and now similarly, so all this has emerged into the growing convergence of the fundamental rights, or the constitutional rights, and the human rights. Okay, and the court in Samata versus the state of AP has rightly said, right to development is also a fundamental right, which is within the part of Article 21 of the Constitution of India. Okay. Similarly, in SR Bommai versus Union of India, the Supreme Court held that secularism is one of the basic features of the India's constitution, and therefore even Parliament cannot amend the constitution in order to take away the secular feature, the secular nature of the India's constitution. So if we see these multiple cases, starting from Keswananda Bharati case, R.L. Coelho, Pachim Bangla, similarly Maneka Gandhi, Joseph Shine. If you see all these cases, then naturally a question arises. The question is, was it due to interpretation of the constitution made by certain judges, or was it inbuilt in the constitution itself? The answer is definitely it is not due to the interpretation made by the judges. The judges of the Supreme Court had taken the seeding from the constitution itself. That is what we call as a constitutional philosophy. So I personally believe the constitution is an organic document. It contains the views, intendments, aspirations, vision, and mission of the architects of the constitution. So it is not due to the innovative interpretation made by the constitution. What the Supreme Court did was, the Supreme Court had taken the cue from the constitutional philosophy, and accordingly it had adopted a dynamic and lively interpretation of the provision, keeping in mind the intendments of the architects of the constitution. So therefore, I personally opine that the constitutional rights and human rights are almost synonymous. So there was a time when we believed that constitutional rights and human rights had some divergence. So during those times, it was supposed that though all the fundamental rights are constitutional rights are human rights, but all the human rights are not the constitutional rights. But now the thin layer between the constitutional rights and human rights has been gradually fading away due to the interpretation of the constitutional rights by the Supreme Court in accordance with the philosophy explicit in our constitution. So from this, what we can understand is the constitutional rights and human rights have almost become one and the same. But at the same time, there is still some element of divergence between the two, in the sense that human rights also include certain important rights like right to human rights also include certain important rights like what you say as right to nature, right to preserve one's culture, right to preserve one's language, right to preserve one's traditions, right to preserve one's so there are so many things, right to preserve, so genealogy. So therefore, to a certain extent, these rights have also been included within the remit of the constitutional rights. That is what I feel personally. So from this discussion, so we started with what the constitution is. So where we understood that constitution is a basic document containing aspirations, intendments, and powers, functions, and limitations on the powers of three organs of the state. And it also contains specific provisions for the blossoming of human personality. Later, so constitution is Bible, Quran, Gita of good governance. And later, we started with what is constitutional transformatism, where we came to know constitutional transformatism is nothing but making constitution relevant, meaningful, sensible, and purposeful to the changing economic and political conditions. And so constitutional transformatism is nothing but making the constitution to meet the needs, necessities, and aspirations of the people. Okay, that is how our constitution, which was drafted and came into force more than 70 years back, is still he's still brimming with life, lot of vitality and vibrancy. I have also cited the research findings made by the Chicago University. The Chicago University has come out with a finding that the Indian Constitution has uh, has vibrancy and vitality. Most of the constitutions across the globe have had a very short period of 15, 20, 25 years, but Indian Constitution has survived even after 70 years. And if you ask, and my personal opinion is, if you ask most of the Indians, if you ask the Indians about about their respect, reverence towards the Constitution, the answer will be that most of them would still hold the Constitution uh, as very dear to them, because our Constitution has given to each one of us most important thing, that is to develop our personality and to aspire for a quality life. So that is the reason why the Indian Constitution has still vibrancy in it. Later, we have seen how what is the nexus or relationship between constitutional rights and human rights. So at the beginning, there was some divergency between constitutional rights and human rights, where it was thought that though constitutional rights are human rights, but all the human rights are not constitutional rights. But now this divergence is slowly, steadily fading away. Now a stage has come that all the human rights are also constitutional rights, and constitutional rights are also human rights, though there is a very slight blurring in between the two. And this is possible because of the interpretation of the constitutional provisions by the Supreme Court, where the Supreme Court has expanded the very remit, where the Supreme Court has extended the very remit, scope, purview of the right to equality under Article 14, and right to life in Article 21, saying that that right to equality invariably demands the egalitarian citizenship, citizens with equal rights. The court has time and again stated, when you treat similarly situated people dissimilarly, then also inequality arises. So the court has steadfastly uh, upheld the principle of equality before law and equal application of laws. And similarly, the court has expanded the origins of Article 21 by saying that almost all the human rights are within the purview, scope, and ambit of Article 21. Okay, starting with the right to access to roads, right to food, right to pension, and the right to live in a pollution-free environment. Okay, and the right to die, otherwise right to die. So all these rights have been included within the ambit of human rights. So I personally feel that we have come to a stage where our constitution now incorporates almost all the human rights. And in this regard, I would like to emphasize emphatically about the essence of Article 51 of the Indian Constitution. Article 51 of the Indian Constitution says the state shall ensure shall endeavor to make foster the state shall endeavor to promote respect for international law and international treaties. But our Supreme Court has integrated and incorporated the respect for international law and international treaties, especially the covenants on civil, political, and economic rights and the Declaration of Human Rights 1948 into many of its judgments, saying that all these rights recognized under the international Declaration of Human Rights 1948, International Covenant on Civil, Economic and Political Rights are within the ambit of Article 21 of the Indian Constitution. So if you see the coherence, relevance, linkage, nexus between these international covenants and the way our Supreme Court has interpreted Article 21 so as to include the most of the rights recognized in international declaration on human rights, for example, right to privacy as stated by the Supreme Court in Puttoswamy case, and similarly, right against discrimination as stated in Joseph Shine case, and similarly, the court in Shabarmala case, all the customs and religious morality must yield to constitutional morality. If you see this kind of analogy, you will definitely come to the conclusion that human rights are also constitutional rights. So therefore, the thin layer of separation between them is gradually eroding, and definitely in the times to come, all the human rights will be recognized as constitutional rights, and constitutional rights are also human rights. So therefore, I personally feel that a constitution is not a mere document of words, phrases, and sentences. It is an organic document having life in itself. So therefore, a constitution should be understood in a manner so as to give effect to the ideals, vision, mission, aspirations, and intendments of the framers of the Indian Constitution, because our Constitution constitutes the collective wisdom of the more than 250 years of our freedom struggle. And that was the reason why it took such a prolonged time for drafting it. Okay. So from this, what I conclude is that there is no mismatch between fundamental, the constitutional rights and human rights. They are one and the same. And with the time that and in the time to come, that in the time to because in the time to come, definitely new arenas will be uh, found by our Supreme Court so as to ensure that human rights, more and more human rights would be brought within the ambit of the constitutional rights, because we are living in a technological driven world where technology is making a lot of inroads into our privacy, our beliefs, and our way of life. So with the emergence of new technologies like artificial intelligence, Internet of Things, machine learning, so on and so forth, there is a greater possibility for these invasive technologies affecting or violating our privacy and our way of life. So therefore, there is a possibility of recognizing new rights within the ambit of the constitutional rights so as to make a perfect consonance between constitutional rights and human rights. So I thank you, each one of you, for your rapt attention, and I express my profound thanks for giving me a wonderful opportunity to share some of my ideas on the topic constitutional transformatism and human rights. If you have any queries, concerns, and clarification on any of the things which I have deliberated, then you are at liberty. Thank you very much.
Thank you, Dr. Divakar, sir. It was an interesting topic, and you took us through various cases, landmark judgments, and really justified how our constitutional interpretation has changed from early 1973 to now. Thank you so much for that, sir. Now I invite Dimple from LLM first year to give vote of thanks.
Everyone. I'm audible.
Any doubts? Does anyone has any doubt?
If anyone has any question, please ask in the chat box.
Parledandi.
Anyone wants to ask any question, please? Yes, Aditya, you can ask your
sir.
question.
Sir, tell me, sir.
Aditya, you are on mute. Unmute yourself and ask the question.
Okay, ma'am. Okay.
Rastanandi, definitely.
Sir, one question is that, sir, as you said that fundamental right.
Okay. Rastanandi.
Just wait for some time. 2-3 minutes. He's on call.
Definitely. Definitely. Istanandi. Sir, definitely. Istanandi. Definitely. Sir, this civil, this asnarandi, mana uniform civil code. Sir. Sir. Thank you, sir. Thank you. Hello.
Yes, sir. Good evening.
Good evening.
Sir, my question is that, sir, as you said that fundamental right or human right is same in constitutionalism transformation.
Yeah. So,
Sir,
you see what?
my question is that, sir, why Indian law provide relief as he commit a crime in society, sir?
Why Indian law? Make it more.
Sir, why Indian law provide relief as he commit a crime in society? Like, sir, a murder victim grant relief on the basis of human right or constitutional right.
So, gentlemen, Mr. Aditya, our entire criminal administration of justice is based on a fundamental principle. Let 99 people escape from punishment, but let not one innocent be punished. Am I correct? So therefore, see under criminal. So see there is always a difference approach between civil administration of justice and criminal administration of justice. You know that very well. In civil administration of justice, the rule that is followed is preponderance of probabilities. But in criminal administration of justice, the rule that is followed is the benefit of doubt. The reason for following this is that even so 99% of the real offenders may escape, but let not one innocent be punished. Okay, so in our system the rate of conviction is around 9 to 10%. Okay, and if you see the around 9 to 10% only, and if you see the Unlawful Activities Prevention Act, the money laundering cases, the rate of conviction is even lower. You understand? So the point is how to strengthen our criminal administration of justice. We can strengthen our criminal administration of justice by integrating the latest scientific knowledge into it. So that is the reason why the central government nowadays is saying that they are going to overhaul the criminal procedure code, and along with they want to strengthen the scientific investigation mechanisms by establishing the scientific labs in every district. So let us hope that they will do all these things. But the point is, the rationality behind it is that even one innocent person shall not be punished. That is the rationality. So in that process, it is true that many offenders get scot-free. But that doesn't mean that our criminal justice system is not working. Okay.
Sir, but my question is that, sir, as he destroyed the life of a person, then why am I guarantee relief, sir?
So your question is, when an offender is violating the life of other, and why should he be allowed? Am I correct?
Yes, sir. Yes, sir. That question is, sir.
You see, it is true. But what are the reasons for crime? Please tell me, my dear. The reasons for crime, the reasons for crime are deeply embedded in the society itself. So a
Yes, sir.
person turns into a criminal because of his maladjustment with the society. Don't forget it. So society has also a responsibility when some of the people take to the crime. Okay. So
Yes.
crime is a result of innumerable factors, which includes maladjustment of the child, bad parental brought up, lack of education, so on and so forth. So you cannot always blame the criminal. So when a person turns into a criminal, it is also a society. It is the collective responsibility of the society to redeem that individual. Don't forget. Okay.
Okay, sir. Thank you, sir.
Thank you. అయిపోయింది రఘు. Okay. Any doubt?
Anyone else wants to ask any question?
I hope I have. You see, that the thing is actually there is a family function, but because I had given prior commitment, so therefore I was not able to justify to my fullest satisfaction. In spite of this, I did well. Okay.
Yes, sir. It was an insightful session. Thank you, sir. So just one question from Rupaksh. Rupaksh, you can ask the question. Rupaksh, you can unmute and
Yes,
ask the question.
good evening, sir. My question is that we have some laws for we have optional protocol second of ICCPR, which talks about the abolishment of death penalty, and India has not ratified or even did not sign that optional protocol. My question
Yeah.
is related to the protection of the person who have committed some crime, and we are giving the capital punishment. So
Yeah.
my question is, don't you think that is a deprivation of life, right to life, and which is guaranteed under Indian Constitution?
No, thing is that as far as the awarding of death penalty is concerned, there is a lot of controversy. In fact, more than 100 countries have abolished it, but our Supreme Court has upheld, saying that death penalty is not in violation of right to life. But if you ask me personally, I say that awarding death penalty is definitely against right to life, because death penalty has been invoked most of the time against the socially vulnerable groups, that is the poor, that is the poorer sections. You see, these poorer sections cannot afford the luxury of engaging a lawyer. They cannot hire better legal talent. So, in fact, some Supreme Court judges, some Supreme Court judges have personally opined after demitting office that the death penalty was awarded against some innocents. They publicly articulated this opinion. So human life, once ebbed away, cannot be revived. So therefore, judges are also human beings. So judges are also vulnerable to committing mistakes. So once a judge or the court awards capital punishment and capital punishment is executed, then the mistake done cannot be undone. So therefore, my personal opinion is death penalty should be abolished. But the most of the experts who support death penalty say death penalty is a deterrent, and it definitely helpful in reducing the crime rate. But that is not true. There is an empirical evidence in the United States of America. Some of the states have abolished death penalty, and some of the states have retained. The states in which death penalty was abolished, the crime rate has not gone up. Okay. Similarly, in the states where death penalty has been retained, the crime rate has not been reduced. That clearly shows the death penalty doesn't have any deterrent effect. Okay. So I personally feel death penalty should be abolished.
Thank you, sir. Thank you.
Dimple Kumari, please proceed.
Hello, ma'am. Good evening, everyone. I'm Dimple, student at the first semester at the University of Karnataka. I'm glad to be here.
Ma'am, your voice is not audible to me. Your voice is not audible to me. Could you make your query more audible so that I can respond?
Dimple, your voice is breaking. So she's just going to give the vote of thanks.
Okay, thank you.
Dimple, your voice is breaking. Maybe you can switch off the video. Maybe it will be more clear. Try that.
Okay, carry on. You go with. You have it. Look after.
Dimple?
No, sure.
I think she has some network issues. On the behalf of Department of Law, Central University of Karnataka, I'm Ragini Rajbur, a research scholar here. Sir, we thank you very much for taking out your valuable time in this busy schedule. Thank you so much, sir, for being a part of this online human rights law lecture series. We are really grateful, and it was an insightful session. I hope all the audience, we have a vivid audience of students, research scholars, practitioners. Some of the participants are teaching assistants also in India and abroad. I'm really thankful for all of you that you participated here. And we again thank you so much, sir, Divakar sir, for being a part of this lecture series. Thank you so much, sir.
Thank you so much.
Thank you, sir.
Participants'
Thank you.
feedback
Thank you so
form
much,
link
sir.
has been mentioned here in the chat box. Also, it will be mentioned in the WhatsApp group. Please fill it. Thank you so much.
Thank you for organizing a wonderful session.